aside the letter of dismissal dated 30th day of January 2017 to January 2017. C, an order directing the first defendant to pay all the salaries and entitlements of the claimant from the 1st December 2017 to January 2018. D, an order directing the first defendant to pay to the claimant 5 million naira damages for wrongful termination of employment of the claimant. E, a declaration that the indefinite suspension of the claimant by the third defendant being an agent of the first defendant is illegal and wrongful for lack of fair hearing. F, an order directing the first defendant to pay to the claimant his entitlement, having worked for 5 years with the first defendant from 12th of December 2012 to 12th of December 2017, as contained in the contract of employment entered between the claimant and the defendant. G, a declaration that the seizure of the 2 hard drives belonging to the claimant by the third defendant being an agent of the first defendant for and on behalf of the first defendant is wrongful and illegal. H, an order directing the defendant to immediately return the 2 hard drives belonging to the claimant. I, special damages of 5 million naira for loss of earning from the claimant's personal material such as claimant's music albums, claimant's well-researched and typed final year project, which was yet to be printed from one of the hard drives before they were wrongfully seized, and the consequential expenditure, trauma, and hardship that accompanied it, having to spend extra year in school due to inability to submit his project caused by the defendant. J, general damages of 10 million naira for psychological trauma, hardship, and stigmatization suffered by the claimant as a result of illegal and wrongful conduct of the defendant. K, 1 million naira cost of litigation. I, a well-worded letter of apology to the claimant for falsely accusing him, thereby tarnishing his image before right-thinking members of the public. The defendants, in their response, filed a memorandum of conditional affairs dated 18th day of June 2019, statement of defense and other accompanying processes dated 12th of November 2019. The claimant did not file any reply to the defendant's statement of defense. On the 6th of October 2021, the claimant testified in proof of his case as CW1. CW1, after identifying his witness statement on oath, adopted same as his evidence in this case. Documents were tendered through CW1. They were admitted in evidence and marked as exhibits C1 to C6. Under cross-examination, CW1 testified that he was self-employed before joining the defendant and that his salary is 68,350 after deductions. He also stated that his salary was paid to him through electronic transfer to his GT Bank account, which was opened for him by the defendant for that purpose. He also stated that he operated First Bank and Zenith Bank accounts. CW1 continued his evidence under cross-examination that his work was on shift basis, 9 a.m. to 4 p.m. and 12 p.m. to 9 p.m. He also stated that he did not make extra money on selling movies. He is aware certain movies were exclusively produced for cinema and such movies should not be found in the hands of an authorized person. He stated that he discharged his duties diligently, that he stated that he was a student, but there is no evidence of studentship before the court. There was no disciplinary hearing. He was issued letter of suspension before hearing, that he was not present when his bag was searched, that he is entitled to certain benefit for working with the defendant for 5 years. The evidence for entitlement is written in his job offer. No any other document except bank statement of account that is before the court. CW1 stated that he paid his counsel 1 million naira cash as deposit. He solicited the money from family and friends, that he did not respond to Exhibit C5. On the 23rd day of February 2022, one Tao Pashusi, a legal manager of the first defendant testified in the defense of the defendant as DW1. DW1 identified his witness statement on oath and adopted same as his evidence in this case. Documents were tendered through DW1 and they were admitted in evidence and marked as Exhibit 8E. DW1 testified under cross-examination that the claimant was an employee of the first defendant. He stated that 2 hard drives were found connected to the administrative office computer, where it was discovered that the drives contained copies of movies that are only meant for cinema. The 2 drives were retrieved from the claimant and were not returned to him because the matter was under investigation, and then this suit was instituted. Due to the nature of the incident involving crime, the claimant was informed that the matter will be reported to the police. As at the time of institution of this case, there was no investigation report. There has been no report of any act as promised against the claimant to the police or any other law enforcement agency. The witness stated that the entitlement as per Exhibit C5 is outstanding salary. The entitlement are yet to be paid as the items are yet to be returned. The case of the claimant. I will skip reading the facts forming the case of the claimants. I will also skip the facts forming the case of the defendants. When counsel got the hard copies, they will read, they will see them.
As the court pleases.
I will also skip reading the submissions of counsel for the defendant. He formulated a single issue. I have captured the argument in the body of the judgment. I will also skip reading the submissions of counsel for the claimant. He formulated 3 issues. I have captured the argument in respect of the 3 issues. So I will go straight to the decision of the court.
As the court pleases. Very well, my Lord.
I have considered the processes filed in this suit, the evidence laid, and the written and oral submissions of counsel for the parties. Having regard to the entire facts of this case, I am of the view that the sole issue formulated by counsel for the defendants will dispose of all the issues raised in this suit. The issue is similar to the 3rd issue formulated by the counsel for the claimant. The only difference is the way they were couched. I choose to be guided by the sole issue formulated by counsel for the defendant due to its elegance and all-encompassing nature. It is also to be noted that with the grant of extension of time to the defendant to file their final written address out of time, issue 1 as formulated by counsel for the claimant has been overtaken by event and become otiose. The 2nd issue of the claimant as well is of no moment, as there is no dispute regarding claimant being employee of the defendant. The issue adopted and as formulated by the defendant is whether the claimant is entitled to any of the relief sought in this suit in view of the totality of the evidence and peculiar facts and circumstances of this case. The position taken by the defendant is that the claimant has failed woefully to discharge the burden imposed on him by the law, as he has not pleaded the terms and conditions of his employment and how the terms were breached by the defendant. The defendants are also of the view that they have adduced credible evidence that the claimant has committed unauthorized transfer and distribution of money of movies to customers and guests, which was discovered as a result of spot check on the claimant's hard drive connected to the office administration computer. The claimant was also accused of copying the watermarked Nollywood movies sent to the first defendant meant for cinema exhibition. According to the defendant, the evidence adduced before the court has established that the claimant was guilty of misconduct, gross inefficiency, exposure of the defendant to legal action, and or financial loss. This has made claimant suspension and termination proper. It is further submitted by the defendants that the claimant's failure to deny or file a reply to the defendant's statement of defense means that the claimant is deemed to have admitted the facts contained in the statement of defense. For the claimant, he insisted that he has established his case by preponderance of evidence and is entitled to relief being sought. The termination of his employment was wrongful on the basis that the claimant perpetrated criminal act of piracy and infringement of the copyright. Counsel refers to Section 15 of the Copyright Act and submitted that the only court having jurisdiction on copyright is Federal High Court, and there was no report of the criminal act to the police. By virtue of Section 131, 132, and 133 of the Evidence Act 2011, a party owes the legal duty of evidential burden of proving the assertion he makes. He who asserts must prove. In the instant case, claimant owed the legal duty of proving the assertions he made against the defendant in his claim, on the basis of which he sought the judgment, be given in his favor. See the case of Mogaji versus Odofin. See also Dibiamaka versus Osakwe. See also Adegoke versus Adibi. See Ziazi versus Bamboshe and Egareba versus Osagi. All the citations have been supplied. It is clear from the provisions of the Evidence Act 2011 and the case law that the burden of proving claims falls squarely on the claimant and not the defendant. The claimant must first adduce credible evidence in proof of his case before the burden shift to the defendant. The guiding principle in determining case presented before the court has been stated by the Supreme Court in Gabriel Atibi versus Kabel Metal Nigeria Limited. The citation has been supplied, which is as follows. A claim is circumscribed by a relief claim. The duty of the plaintiff, therefore, is to plead only such facts and material as are necessary to sustain the reliefs and adduce evidence to prove same. He may at the end of the day obtain all the reliefs claim or less. He never get more, nor does he obtain reliefs not claim. A court is therefore bound to grant only reliefs claim. It cannot grant reliefs not claim. The implication of the above dictum to the dictum of the Supreme Court to the case of the claimant is that the reliefs the reliefs being sought by the claimant will accordingly will determine the case of the claimant. Therefore, there are 12 reliefs being sought by the claimant before the court. The reliefs have been reproduced in the earlier part of the judgment. I shall consider the reliefs in the order of their listing. Relief 1, Relief A, is praying for declaration that the termination of claimant's employment by the first defendant is illegal and wrongful for lack of fair hearing. The question to be resolved regarding these reliefs is whether the claimant's termination of employment by the defendant is illegal and wrongful due to alleged lack of fair hearing. In attempting to answer the question posed, the defendant has argued that the claimant has failed woefully to prove his case due to absence of terms and conditions of service governing the employment of the claimant. While the claimant insists that he has proved his case, he has proved that he is entitled to relief being sought. The Supreme Court decision in the case of Bukar Modu Aji versus Chad Basin Development Authority and another is a guide on this issue. The Supreme Court has held that waving a flag of breach of constitutional right to fair hearing does not provide any saving grace once the conditions of service are not pleaded and brought before the court by a claimant who is complaining of wrongful termination or dismissal from employment. In other words, the claimant must first plead and prove his conditions of service before any talk of breach of fair hearing can be entertained. The conditions of service is accordingly sine qua non in any claim for wrongful dismissal or termination, for it is only the condition of service that the court is allowed to consider in determining the wrongfulness or otherwise of dismissal or termination of employment. From the state of pleadings, more especially the statement of facts, which represented the pleading of the claimant, it is clear to me that the issue of termination of claimant's appointment was pleaded. However, there is nowhere the claimant pleaded the terms of the contract of service between him and the first dependent. This is very necessary to do so, as the terms and conditions of service is a bedrock of the relationship between the claimant and the first dependent. Indeed, it is what governs the entire relationship. It is mainly through the contract of service or terms and conditions of service when pleaded that it will be shown or established to the court that the nature of the duration of the contract of service and the method to be adopted by either of the contracting parties when he or it chooses to opt out of same, or the time at which notice to determine the contract may be given. All these important issues are nowhere pleaded in the statement of claim, and an important source to get them were also not tendered in evidence. It is tried to know that when an employee complains of wrongful termination of his employment by his employer, he has the onus to prove the wrongful termination of the said employment by placing before the court the terms and conditions of the contract of employment, and B, proving in what manner the said terms were breached by the employer. It is not the duty of employer as a dependent in any action brought by employee to prove any of these facts. See the case of Cato versus CBN. See also Amodu versus Amode. See also Angel Spring versus Dine Limited versus Aja. All the citation has been supplied. It is clear from the case law where there is absence of pleading of terms and conditions of proof and conditions of service and proof of same, the court will be left empty-handed without anything that can assist in determining the rights and obligations of the parties. If there is any breach, such cannot be determined without the terms and conditions of the contract between the parties. This is because the Supreme Court in the case of Amodu versus Amode has held that terms of contract of service are the bedrocks of any case where the issue of wrongful termination of employment calls for determination. In the instant case, such terms and conditions of the contract of service and how the said terms and conditions were breached by the first dependent were not pleaded, nor were they brought or placed before the court. This failure or neglect on part of the claimant is fatal to his case. See the case of Rector Kwara State Polytechnic versus Adefila. See also the case of Pomo Oil Palm Company versus Iserehead. It is to be noted, it is to be reiterated that the failure of the claimant in this case to plead and put in evidence the terms and conditions of contract of service between the parties has completely knocked off the bottoms of his case, thereby depriving the court of the power to consider the wrongfulness or otherwise of the terminations of claimant's employment. This notwithstanding the issue of fair hearing or lack of it, as fair hearing cannot exist or considered in the absence of the foundation of the act being complained of. This means the claimant's relief seeking for declaring termination of his employment illegal and wrongful due to lack of hearing failed, and the conditions precedent for consideration of the relief has not been fulfilled. See Abba Aji versus Chad Basin Development Authority, SUFRA. It should also be noted that relief A is for declaration, which means claimant must establish his entitlement to the reliefs of declaration upon the strength of his own case and not on the weakness or admission of the defendant. See the case of Badamosi Sorry, counsel, hello? Sorry, I will continue.
My lord, sir, I'm here, sir.
I will continue where I stopped.
Okay, very well.
Therefore, in the case at hand, the claimant has failed to establish entitlement to reliefs. A. In Yusuf versus Damian Aviation Nigeria Limited, it was held that a party that failed to prove terms of employment is not entitled to declaration that the termination was wrongful. Failure to adduce evidence of terms and conditions of service will disentitle a claimant from grant of declaration that termination of his employment was wrongful. See also the case of Moroflo versus Kwara State College of Technology. The defendant have submitted that the claimant's failure to file a reply to the statement of defense, the claimant is deemed to have admitted the facts pleaded in the statement of defense. The law has long been settled in a long line of judicial authorities, replete in our law reports, that evidence that is unchallenged and uncontradicted by the adverse party is good to be acted upon by the court, unless it is either irrelevant or palpably false or worthless by itself. Therefore, the mere fact that evidence is unchallenged is not tantamount to proof of such an unchallenged evidence. Must also be the evidence, the unchallenged evidence must be credible and relevant in relation to the facts in issue it seeks to establish. See the case of Cameroon Airline versus Mike Otutuize. See also Ishola versus Lawson. See Ishola Lawson versus Afani Continental Company Nigeria Limited. See also Omorebe versus Lawan. See Oduola versus Coca. Relating to the above decisions to the facts abad in the dependent statement of defense, can it be said that the claimant's failure to file reply amount to admission of abatements in the statement of defense? The answer to this further will be revealed upon interrogation of the abatement. The defendants relied on paragraphs 12 of the statement of defense and corresponding evidence in paragraphs 10, 11, 12, 13, 14, 15, 16, 17, 19, and 20 of the witness statement on oath of DW1, which was adopted before the court as evidence of the defendant in proof of the defense put forward by the defendant. They also rely on Exhibit D. A careful perusal of the evidence of the defendants through their witness DW1 will show that his evidence is hearsay. DW1 was at no material time to this case present at Calabar, where the incident that led to this suit occurred. DW1, from his own evidence, he is a staff in the legal department of the first defendant at his head office in Lagos. Though the law does not compel any party to call a particular witness to testify, however, any witness to testify must be one that has personal knowledge of the facts on which evidence is being given. DW1 not involved in the alleged discovery of the plugin or connection of claimant's hard drive to the office administrative computer is not appropriate officer of the first defendant to testify in respect of that evidence. The appropriate officer to give such evidence is second defendant, but she was not called to testify, though her name was listed as witness in this case. She never appeared to testify. In the circumstances, I reject the evidence of DW1 as hearsay, which does not in law command any evidential value. The defendant has also pleaded to rely on query of 11th day of December 2017 and the answer given by the claimant. Those documents were never tendered in evidence by the defendant. Therefore, all the abatement on which the defendant relied on those documents has not been proved. The implication is that they have been abandoned. The failure of the defendant to tender the seized hard drive, which is at the center of the controversy, is fatal to the defendant case, and Exhibit D cannot cure the defect. In view, cannot cure the defect, and those people that have, and those customers of the defendant that have also informed the defendant that they can testify have not also been, those who have given, those customers of the defendant who said they have paid money to the claimant for the videos for the alleged movies have not been called to testify as witnesses. In view of the foregoing appraisal of the defendant's pleading and evidence, it will not be right to say that the claimant's failure to file reply is deemed to be admission when the purported evidence adduced in proof of pleaded facts has no evidential value in the eyes of the law. Relief B is for an order setting aside letter of dismissal dated 30th day of January 2017. This relief is dependent on the grant of relief A, having refused to grant declaration. Relief B being an ancillary claim must also fail. Furthermore, from Exhibit C5, the claimant's appointment, which the first defendant was terminated and not dismissal. This means relief V is at variance with the facts of this case, as there was no dismissal of the claimant's appointment by the first defendant. Relief C is for an order directing first defendant to pay all salaries and entitlement of the claimant from 1st December 2017 to January 2018. A careful perusal of Relief C will show that it is a claim that is vague and imprecise. It lacks certainty. Therefore, by authority of the Supreme Court decision in the case of University of Jos versus Dr. Ike Guoha, it is no claim at all. The vagueness of the relief is revealed in the absence of precise amount being claimed for salary for the period of 1st December 2017 to January 2018. Relief D is an order directing first defendant to pay claimant 5 million naira damages for wrongful termination of employment of the claimant. This is an ancillary claim to Relief A. Therefore, failure of Relief A means failure of Relief D. Even if the termination of employment of the claimant is found to be wrongful, which I did not find, the claimant will not have succeeded in respect of this relief. The reason being that in employment cases, damages recoverable for wrongful termination of employment is prima facie the amount that claimant would have earned for the period of notice of termination. See the case of Western Nigerian Development Corporation versus Jimo Abimbola. See also Nigerian Produce Marketing Board versus Adeumi. See also African Newspaper versus Akano. See also Akin Fosile versus Mobile. See also Interdrill Company Nigeria versus Ajijala. See also Imolome versus Wagek. See also Chukuma versus Shell Petroleum. See also Isewore versus Nefa. Relief E seek for declaration that indefinite suspension of the claimant by the second defendant as agent of first defendant is illegal and wrongful due to lack of fair hearing. According to the claimant, sometimes in 2017, he was issued with query as email, via email, and he answered the query. Exhibit C shows that on 25th day of August 2017, the claimant was issued with a query by the second defendant, and he answered the said query. The answer to the query is as shown in Exhibit C, but the query itself was not tendered in evidence by any of the parties. Another query was issued to the claimant as per Exhibit C1, but there is no response to the said query tendered, and the claimant has not stated in his pleading that he answered the said query in Exhibit C1. The claimant has stated that on 12th day of December 2017, the day he appeared for hearing, he was issued with Exhibit C2, the letter of indefinite suspension from duty. He also stated that the suspension was slammed on him without giving him fair hearing. The law is right that a court of law will not grant declaratory relief unless such relief has been proven by evidence by the party seeking such relief, regardless of whether or not the party on the other side filed evidence or not. The claimant seeking for declaratory relief must prove his case on the strength of his evidence, not on the admission or weakness of the defendants or absence of defense. See the case of Okereke versus Umahi and others. See also Nison Wike Nison versus Peter Side and others. See also Nigeria. See also the case of Nigeria versus Moinye. See also Dumes Nigeria Limited versus Uwakoba. And the case, see also Bello versus Iwaka and Mutuanshe versus Shorube. All these authorities insist that the claimant framed for a declaratory relief must prove his case on his own evidence and not on evidence of the defendant. With that, the claimant is entitled to grant of the with the state of the pleading and evidence of the claimant, can it be said that the claimant is entitled to grant of declaration that his indefinite suspension is illegal and wrongful due to lack of fair hearing? The word suspension has been defined in several decided cases to mean a temporary privation or deprivation, cessation, or stoppage of all form from the privilege and right of a person. It carries or conveys a temporary or transient disciplinary procedure which keeps away the victim or the person disciplined from his regular occupation or calling, either for a fixed or terminal period or indefinitely. The disciplinary procedure gives the initiator of the discipline a period to make up his mind as to what should be done to the person facing the disciplinary discipline. In other words, suspension is usually a prelude to dismissal from an employment. It is neither a termination of contract of employment, nor is it a dismissal of the employee. It merely operates to suspend the contract rather than terminate the contractual obligation of the parties to each other. See the case of University of Calabar versus Asiaga. See also the case of Longe versus First Bank of Nigeria PLC. See also Nweke versus Unizik Oka. The claimant in this case was suspended by Exhibit C2, which pegged the suspension to be pending further fact-finding investigation on act of movie piracy and several inconsistencies observed by audit report on claimants to post-sales report. Exhibit C2 further stated that the police will be involved to assist with the investigation. It is clear to me that the suspension is a weapon put in the hand of an employer for purposes of curtailing excesses of his employee and ensuring maintenance of discipline in workplace. Exhibit C1 clearly is in unequivocal terms stated that the suspension of claimant is for investigation of movie piracy and inconsistencies revealed by audit report on claimants to post-sales report. There is no doubt when there is allegation of serious misconduct, more particularly bordering on commission of crime, employer will no doubt have power to suspend an employee of whatever status to allow room for discreet investigation of the allegation. From the reasons proffered for suspension of the claimant, suspension of the claimant is justified. This is so as the claimant has not referred to the court to any policy or terms in the conditions of service that prohibited taking such action by the defendant. It is to be noted that in law, suspension of an employee is not an unusual procedure taken in order to facilitate an investigation. Thus, an employee affected by suspension can hardly complain of not having been given fair hearing, nor can he demand that the rule of natural justice should apply. The interest of the business of the employer becomes paramount, and the employee is made to keep up the premises thereof until later in time. See the case of Shell Petroleum Development Company versus Lawson Jack. The case of the claimant was made worse by issuance of Exhibit C5, later terminating claimant employment with the first defendant. Therefore, the claimant has not proved entitlement to declaration that his suspension from work was illegal and wrongful. That relief failed and same is hereby dismissed. The next relief F is praying for an order directing the defendant to pay the claimant his entitlement for having worked for 5 years with the first defendant from 12th of December 2012 to 12th of December 2017, as contained in the contract of employment entered between the claimant and the first defendant. This claim is predicated on the contract of employment entered into between the claimant and the first defendant, but no such contract has been placed before the court for the court to be able to find whether there was such an entitlement provided for the claimant. Furthermore, the way and manner the claim was couched, relief F is vague and imprecise. The court cannot grant this kind of relief, as the court is not allowed to speculate. For any relief to succeed, it must be precise with no ambiguity. The claimant has not stated the exact amount he is claiming and has not also adduced any evidence from the terms and conditions of service that grant him such claim. This means the claimant has failed in his duty of proof and is not entitled to this claim. In support of my finding, I refer to the case of University of Jos versus Dr. Ikegweha Sufra, where the Supreme Court stated at page 506, paragraphs A to B, a claim that is vague and lacks certainty is no claim at all. In the instant case, in paragraph 13B of the respondent's statement of claim, he sought an order directing the appellant to confirm him as a lecturer in the Department of Political Science of the University of Jos, with effect from 27th day of January 1995. With all promotions, allowances, and entitlements, the respondent did not state with certainty what his allowances are, the entitlements were, and how he earned his promotions from one grade to another, and for which period. These vital facts were not backed by any evidence. All the reliefs regarding promotions, allowances, and entitlement were vague, uncertain, and unascertainable, and lacking in particulars and proof of evidence. All the reliefs pertaining to promotions, allowances, and entitlement being reliefs that were vague, uncertain, and lacking in particulars and proof by evidence must fail. End of quote. In the above case, the apex court further stated that for a party to be awarded any relief by a court of law, that party must not plead with particularity, must not only prove with particularity, but also must prove by credible evidence and convincing evidence that he is indeed entitled to the reliefs he seeks. A court of law has no jurisdiction to grant a party that which he has not asked for. Court ought not to play the role of Father Christmas, which can go around granting parties reliefs which they have not asked for. See the case of Odofin versus Agu, Okoko versus Dakolo, Ayombade versus Balogun, Ige versus Oluloye, Asta versus Gachi, Ladoke versus Olaboye, Awosile versus Sotumbo, all the citations of light. The claimant has also failed to prove entitlement to this relief, same is hereby refused. Relief G, H, and I are reliefs bordering on declaration that the seizure of the two hard drives belonging to the claimant by the second defendant, being an agent of first defendant for and on behalf of the first defendant, is wrongful and illegal. He also seeks for immediate return of the two drives and payment of 5 million naira damages for loss of earning. The claimant has stated that sometimes in 2017, he left his bag containing his two hard drives and other personal effects in his office at Marina Resort branch, as he has been doing in the past. But by the time he came back, his bag had been ransacked by the second defendant for no justifiable reason, and the second defendant did not tell him the reason for breaching his privacy in ransacking his bag in his absence. According to the claimant, the second defendant did not tell him anything about pirated movies, but proceeded to issue suspension letter to him and invited him to appear for hearing. However, when the claimant realized that the first defendant is no longer operating at Marina Resort office, he engaged the services of a lawyer to write to the first defendant demanding for the payment of his entitlement and release of his 2 hard drives, see Exhibit C3. The first defendant, instead of paying him his entitlement and releasing his 2 hard drives, it wrote to the claimant attaching letter of termination of claimant's employment with effect from 30th of January 2017. See Exhibit C4 and C5. The defendants, on their part, have stated that the claimant is in contravention of the first defendant policy, transferred watermarked highly classified Nollywood movies, which were sent to the defendant by film distributors for exhibition exclusively within its cinema to his personal hard drive, and regularly shared the said movie with customers as just for monetary compensation. According to the defendants, the finding came to light upon on the spot check of claimant's personal hard drive connected to the defendant's administrative computer. The second defendant discovered the claimant's second hard drive in the office safe. The 2 hard drives were sent to the defendant's support service office for extensive investigation. The claimant, under cross-examination, maintained that the second defendant searched his bag and confiscated his 2 hard drives containing his personal effects. The defendant evidence that the claimant hard drives were connected to the administrative office computer has not been proved before the court, because the person who allegedly discovered the hard drive connected to the administrative computer, though listed as witness, was never called to testify before the court. Though the defendants are free to call any witness to testify in the defense, the witness to be called must be a witness that is involved in the act being complained of, on which the evidence is being given. In view of this finding, I found the story told by the claimant under cross-examination to the effect that the defendant searched his bag and confiscated his 2 hard drive as true. With the evidence before the court, the claimant is entitled to declaration that the search of his bag and confiscation of his 2 hard drives by the second defendant on behalf of the first defendant is illegal and wrongful. In fact, to make the defendant case worse, those customers that were allegedly that the claimant was alleged to have given them the movies, copies of the movies, have not been called to testify before the court. And they said even the hard drive has not been reproduced, as Exhibit D cannot stand instead of the said hard drive. Relief H is for an order directing the defendant to return to the claimant the 2 hard drives seized by the defendant. Having found the confiscation of the claimant's hard drive to be wrongful, common sense dictates making of an order for return of the 2 hard drives to their owner, i.e. the claimant in this suit. This order is more plausible having regard to the fact that the defendants are yet to report the alleged act of piracy against the claimant to any law enforcement agency. The defendants have no right to continue to hold claimants' hard drive, more particularly when they had completed their own internal investigation. If there is any other criminal investigation, it should be by the appropriate law enforcement agency responsible for prosecution of copyright violations, and not the defendant. What remains to be determined on this issue of the 2 hard drive is the claim of 5 million naira special damages for loss of earning. This claim being claimed for special damages, the law requires the claimant to specifically and specially plead it and prove it strictly. Is also required to particularize and strictly prove the entitlement to the claimant for special damages. Claim for special damages must be capable of substantially exact calculation, as the law does not infer from the nature of the act complained of. They do not follow the ordinary course. They are exceptional in their character, and they must therefore be claimed specially and proved strictly. See the case of Julius Berger Nigeria Limited, PLC versus Onwabu. See also 7-Up Bottling Company versus Clippo. In the case at hand, the claim for special damages are for loss of earning in respect of personal materials such as alleged musical albums, research and type final year project, which is yet to be printed, among others. The claimant further stated that he had to pay heavily to process new project as well as other important documents contained in the hard drives. The claimant has, however, failed to strictly probe exact loss of these personal materials, which the claimant allegedly lost earning on them. Apart from ipse dixit of the claimant, there is no any other evidence to prove the alleged loss. There is no evidence to establish that the claimant was a student in the university. There is also no evidence to prove that the claimant is into music and had actually produced any album. On the alleged new project, the claimant had not tendered a copy of the new project, nor tendered any receipt showing the heavy money which he allegedly paid or spent in producing the new project. The court was also not told how much money was lost for each of the items of loss. Therefore, the claimant has willfully failed to establish entitlement to the claim for 5 million naira special damages as a relief H. The next relief being sought by the claimant is relief J, which is on 10 million naira general damages. The law is settled that a claim for general damages are distinct from special damages. They are such as the law will presume to be the direct, natural, or probable consequences of the act complained of. See the case of Odula versus Haddad. The grant of general damages is at the discretion of the court after considering the entire case presented before the court. Another item of claim is as contained in Relief K, which is claimed for 1 million naira cost of litigation. Like the general damages cost of litigation is at the discretion of the court after appraising the case put forward by the claimant. The last relief I, which is for letter of apology, the claimant having not established entitlement to claim or declaration for terminations of his employment is illegal or wrongful, is not grantable. He has not also been able to establish how his reputation was damaged, as there is no evidence of such damage to his reputation. From all I have been saying above, the claimant succeed in fact only in respect of seizure of his two hard drive, which was by the second defendant on behalf of the first defendant. Therefore, the defendants are hereby the seizure of the two hard drives are hereby declared wrongful, since there has been no intention on part of the defendant to report the said alleged piracy to any law enforcement agency. The claimant is entitled to have his two hard drives returned to him. The defendants are hereby ordered to immediately return to the claimant his two hard drives seized by the second defendant on behalf of the first defendant. In the final analysis, in the sum total of all I have been saying above, and I hereby award the sum of 500,000 naira cost against the defendant. The defendants are hereby ordered to pay to the claimant the sum of 500 naira cost to the claimant with immediate effect. Judgment is entered accordingly.
As the court pleases.
As the court pleases, we are grateful to your lordship.
You are welcome. Before you get the hard copy, the judgment will be posted on our website by tomorrow, so you can access it on our website before you get the hard copy.
As the court pleases.
Registrar, any other matter?
No, my lord, that's all, my lord.
Okay, thank you very much.
Thank you, my lord.
So, counsel, you are welcome.
Thank you very much.
Have a nice day.
Thank you, my lord.
The administrator of the sitting, please, you can discontinue the sitting. Thank you.
Thank you, my lord.
Okay, bye.
Bye, my lord.